Good evening and welcome to the first 42BR Barristers Employment webinar being held in our new building in 11 Staple Inn. This is Louise Whittington, I'm Amy Stroud, and we're very pleased to be with you this evening to talk about privilege, check your privilege, recent developments in the law of without prejudice privilege and legal advice privilege. There is a disclaimer which I will bring up just to remind you this is an oversight. It shouldn't be considered as an alternative to informed legal advice. If you have any questions, please put them in the Q&A box and they will hopefully, time permitting, be addressed at the end of the session. There will be an email with a recording, a feedback form and slides which will be circulated tomorrow, and the recording should of course, as usual, be available on our website and YouTube channel. So without more ado, I'm going to hand over to Louise.
Good afternoon, everyone. I just wanted to provide an overview of what we'll be discussing today. As Amy has indicated, it's a little bit of a whistle-stop tour of some of the recent developments from 2023 and 2022 on really with the without prejudice rule and legal professional privilege, which is the Dundee and Chakraborty case, which I'll be discussing in a moment. We'll also, at the end of the session, go through some practical considerations for you all to think about when you're conducting the litigation. I'm aware that most people joining us this afternoon will be specialists and practitioners in employment law, and so apologies if this is a slightly basic introduction. But just as a refresher, and for those who want an outline, it's easiest to think of privilege in two separate categories: legal advice privilege and litigation privilege. The first category, which is set out on the left, is somewhat broader. It's the protection of correspondence and documents and all advice given in the course of correspondence between, or discussions between, a client and their representative. And there are strong policy reasons why, which are emphasised in the authorities, why this protection is given to this type of advice, to enable people to have full and frank discussions with their own representatives and obtain advice. It does not need to be advice in the context of litigation per se. It could be quite a lot broader than that. It could be advice about rights and obligations more generally. But if it's in the context outside of litigation, then it would need to be legal in nature to attract the protection of legal advice privilege. But there's also circumstances where an individual can waive privilege, which we don't get into necessarily in this talk because it's not in apart from a discrete point in one of the cases, it's not necessarily dealt with extensively in the authorities we're considering. And you'll all be well aware of, and I'm sure, advising your clients on the dangers of forwarding documents or losing privilege, because it's right to focus on the fact that this is protection afforded between a representative and their client. And so if a document is forwarded to a broader organisation or colleagues, you may lose or waive the privilege. The second category is litigation privilege, which can be between a representative and a client, or between third parties, such as parties conducting settlement discussions or investigations into a dispute. But this must be in the course of litigation or in consideration of a dispute, which is being considered in some of the authorities we're looking at this afternoon. Simply having a label of without prejudice, as Amy will explain, does not necessarily mean that a document is without privilege. It's going to depend on the context. And again, something to bear in mind when looking at litigation privilege is the policy reasons of why there are so limited exceptions when these documents will be disclosed into proceedings. So looking at the first case of University in Dundee and Chakraborty in 2023, this was an appeal from the EAT to the Court of Session in Scotland. And in summary, the claimant was seeking disclosure of an original draft of an investigation report prepared following a grievance that he'd raised against one of the professors at the university. Just by way of context, the claimant had brought a claim in the tribunal in the December of 2021, which was before the report was finalised by Professor Garad in February 2022. The respondent employer had instructed a legal team, possibly in the course of the litigation having been started in the tribunal, and they sought their input into the grievance investigation report. And commenting on the report, potentially, this is a supposition, but about commenting on some of the findings that were made as they're related to allegations of bullying and discrimination, which was the substance of the claim. What's important to remember is, what was important in this case in particular, was that the investigation report that was disclosed to the claimant was the 5th version of that investigation report. And there was a footnote that it had been amended following independent legal advice. The claimant was therefore on notice because this version, or the version that he received, was not the original version of the report that had been prepared by the professor tasked with conducting the investigation. What was accepted and was conceded by the respondent and the employer in the course of the proceedings was that the original version of the report was created before the legal advice was tendered or given. And so under the normal rules, the original version of the report would not be privileged. The two grounds or two issues that were raised in this case was whether the original version could retrospectively become privileged when the final version was issued, because of the comparison between the differences in the original version of the report and the 5th version of the report. And therefore the claimant could know what advice was given. And if it had attracted privilege, was it waived by the appellant, so the employer, by their conduct? And the judgment was given by Lord Carloway, and just set out at paragraph 17. I think it's helpful just to consider this paragraph because it just sets out the very basic position that advice would be confidential, the advice that was gained about the investigation report and any comments made. But it's the fact that what the employer was trying to do was withhold or not disclose the original version of the report, rather than specifically the advice that had been given to the professor conducting the investigation. And at paragraph 19, it was said that confidentiality can extend to material that will allow a reader to work out what legal advice had been given. So there are particular exceptions, most notably in the Three Rivers case, that would allow a document to become privileged because you're able to work out what advice was given. The court drew the distinction following re-Edwardian Group from 2017 between two separate or types of document, one where a definite and reasonable foundation of the advice and the substance of advice that was given can be worked out or can be ascertained, and one where it's possible to speculate or wonder about the legal advice by entering into a comparative exercise. And the Court of Session considered that the advice, that the original version of the report fell into the latter camp, that actually you would need to sit the documents side by side and look at the differences. And even then, you wouldn't necessarily be able to tell specifically what advice was given. It would still be a speculative exercise. And so for those reasons, it was considered that it did not fall into one of the categories within the Three Rivers that would afford the original version of the document the protection and privilege of the legal advice privilege. The Court of Session actually went on to determine the second issue, that if it had obtained or attracted privilege, had that privilege been waived by the employer's conduct. And again, consideration was given in the judgment to Scottish Line Insurance Company and Goodwrench Court in 2011. And it was an objective assessment into the behaviour. And what was noted was the fact that the person who was carrying out the investigation was appointed in accordance with a bullying harassment policy of sorts, and was meant to be conducting this as an independent, impartial investigator. And the fact that advice had been sought and had input into the version of the report which was eventually disclosed to the claimant and which would be relied on in the proceedings and would be an influential document, meant that their behaviour, they'd waived the privilege if they had obtained it in the first place. And what, again, just one point to bear in mind is that, and something that does come across in the judgment, is if the appellants had not disclosed the fact that this was the 5th version of the report and had included a head of footnote that this had been subject to independent legal advice, then the claimant would not have known that this was not the original version of the report. Perhaps as an underhand tactic, but the Court of Session did comment on the fact that it was an essence of the employer's own making that they'd disclosed to the claimant that this wasn't the original version of the report. I will now hand over to Amy to consider an outline on the without prejudice principles.
Thanks, Louise. So I want to, before looking at the two principal cases that we're discussing this evening, I just wanted to have a very, very quick whistle-stop tour of the legal framework that underpins without prejudice privilege. And of course, I'm sure you'll be familiar with all of it. The question of the policy, the important policy set out in Cuts and Head, that parties should be encouraged to settle their disputes without resort to litigation and have a forum where they can speak freely. And of course, the importance of those discussions being genuine. There needs to be a bona fide attempt to resolve the dispute. Also, of course, that the term without prejudice, whether it's at the top of correspondence or it's used in a meeting, is not determinative. As you can see from the Faithorn-Farrell-Timms case, you have to look at the context of the circumstances of the particular exchange and whether that can render it privileged. And also, of course, it's an objective test. So it's not what the parties objectively thought about the communication at the relevant time, but rather on a reasonable basis, what was the intention of the author and how would it be understood by a reasonable recipient? So, of course, it's important not to focus too much on the subjective views of the parties. And of course, the leading case of Barnetson and Framlington Group, again, very well known, had several elements there that it's perhaps wise to quickly revisit before looking at Garad and Evanson. The opening shot principle that's discussed in Barnetson of an initial proposal in negotiations before proceedings have begun that can be protected by privilege. Otherwise, how can a party ever safely make an initial offer in response to a claim? And that's actually a principle that's central to the respondent's case on appeal in Evanson. And the very important question of the boundary that's drawn between serving the policy interest of enabling the parties to try and settle without fear of that information being before the court or tribunal, but also the need for a party to be able to present its case at its best and not being impeded because of privilege preventing that the disclosure being made. So there is that balancing act which Barnetson deals with, because of course if you were to say that the privilege doesn't take effect until the litigation is expressly threatened, that undermines the very principle, the very policy in Coots, because there's an incentive on the parties to escalate the dispute to the point where the threat is made, so that they can take advantage of the privilege, and that undermines the whole process of trying to settle. And Barnetson recognises it's not always an easy line to draw. And of course, we also know from Barnetson the concept of it not necessarily being about temporal proximity, what's nearest in time being covered, but subject matter can be more pertinent. And so the key formulation that's really critical in these cases, whether in the course of negotiations the parties contemplated or might reasonably have contemplated litigation if they couldn't agree. If so, the privilege applies. If not, the privilege does not apply. And so let's look at Garad. Mrs. Garad was a company secretary. She had been on maternity leave, returned July 2019, and then in October 2019 announced that she was pregnant again. She submitted a grievance at the end of October. citing pregnancy and maternity discrimination, harassment, detriment. The respondent's HR and employment law advisor, Mr. Sherard, invited her to a meeting on the 8th of November, which was termed a preliminary discussion, and it was held at the local golf club. She was offered the services of a legal advisor at the employer's expense, but she declined that. And it's probably worth saying, because it's relevant more generally in Garad, that both she and her husband, who accompanied her, had law degrees. She had completed the LPC and he had a PhD in law. At the meeting, Mr. Sherard discussed the grievance, asked the claimant about it and what she wanted from it. And he put a proposal to her, which involved terminating her employment and offering her £80,000. This wasn't accepted by her, either at the meeting or afterwards, and she resigned. There were key differences in the parties' evidence. The respondent's evidence was the meeting was without prejudice, and it was an initial exploratory conversation about settlement and the possibility of making a severance payment to the claimant. The witness described the relationship as her employment relationship as fractured and problematic. On the claimant's side, her evidence was she had felt ambushed. She'd said Mr. Sherard was aggressive, and at one point her husband had been told to shut up. And she also said, and this is quite telling given what I've said about their legal experience, that neither she nor her husband understood what without prejudice meant. They tried to query that. I think perhaps unsurprisingly, and certainly in terms of that, the judge didn't actually believe her there, and the judge generally did not like the claimant's evidence. She found there was a dispute at the date of the meeting. The parties did contemplate, or might reasonably have contemplated, litigation at that stage. The judge relied upon a number of matters. Firstly, that the respondent had genuinely wanted to settle this. Also, that the claimant in her grievance had referred to ACAS, referred to early conciliation or mediation in the body of her grievance. And this had weight for the judge. There were also issues relating to claimant's assertion of unambiguous impropriety. I'm going to let Louise deal with that in her section of the talk. So the claimant appealed this. It went to the EAT, and the claimant's legal team, in fact, relied on the case of BNP Paribas and Mezzo Terro in arguing that the meeting was not covered by without prejudice privilege on the basis that there was no dispute at the time. You may recall from the Mezzo Terro case, which superficially has some resemblance to this, that was also concerned about a grievance of maternity discrimination, and where the claimant, Ms. Mezzo Terro, was invited to a meeting with the employer where she was presented with a termination package. And so in that case, the tribunal had held that there was no without prejudice privilege that protected that meeting, and that was upheld by the EAT on appeal. So the claimant in Garad said, well, my case is virtually indistinguishable from Mezzo Terro. The tribunal has simply attached too much weight to my grievance. It was obvious that the purpose of my grievance was to avoid a dispute and that I wanted to keep my job. However, the EAT disagreed with that. It said, while yes, applying Mezzo Terro and the simple fact of a grievance doesn't necessarily mean that without prejudice privilege applies, you need to look at the nature of the grievance, the manner it's raised, the circumstances in which it's raised. And Mezzo Terro is in fact very different. There, the claim went on to claim discrimination and victimization, and the victimization actually relied on the meeting as an act of victimization itself. So to this extent, the content of Ms. Mezzo Terro's grievance and the complaints that formed her claim in tribunal were quite different. In Garad, conversely, the meeting is not part of her claim itself. The contents of her grievance very largely corresponded with what she claimed at tribunal. And in fact, that meeting she had with Mr. Sherard was rather part of the narrative, explaining why she felt the grievance wasn't dealt with satisfactorily. So it is important, when you look at Garad, not to draw too hasty conclusions about what impact a grievance might have in relation to establishing privilege. And the grievances are very fact sensitive. And you have to really bear in mind, one point is to bear in mind the correspondence of that grievance with the eventual claim. The second recent case that we're concerned with is Shelderbauer and Martin Evanson, a rather different case. Mr. Evanson was a chief risk officer and he brought a claim for unlawful deduction of his wages. This paragraph you'll see on the slide was from his grounds of claim. He refers to a 20th September meeting and an offer that the respondent made for his outstanding holiday pay amounting to rather hefty £68,000. And the issue was that this shouldn't have been in his grounds of claim. It was covered by without prejudice privilege. Naturally, the respondent didn't want that to go before the tribunal. But at a preliminary hearing, the employment tribunal concluded that no privilege was engaged until a lot later, the provision of draft settlement agreements between the parties in mid-December 2018, so several months after that. It's worth just briefly exploring the chronology of Shelderbauer. We see here there was a meeting following the pleaded 20th of September meeting, 12th of October, where they met to discuss terms of termination, and then ensuing email correspondence, excuse me, in late October, at which point there was largely agreement, except on the narrow issue of holiday pay. And then we have the mid-December date where the draft settlement agreements are exchanged and the claimant was dismissed in March without that being resolved. Now, it's probably worth saying that, in fact, it's not relevant to the issues of privilege, but the tribunal didn't find that the September meeting happened. So it was really concerned with the October events onwards. But what it was clear about was that the meetings in October were not covered by without prejudice privilege. And the tribunal was influenced on these various points. Why wasn't it privileged until mid-December? Firstly, and quite importantly, this was not a dismissal that was fault-based. It was not for conduct-related matters. It was a purely amicable situation where a senior employee wasn't needed anymore. And neither party bore hostility to the other. There was no stigma between attaching to the claimant's position. Simply his services weren't needed anymore. And the judge concluded a reasonable person would not have a basis for thinking from the outset that litigation was an option. The tribunal was also influenced by the fact that the parties had gone a long way in the initial October meetings to agreeing all the components, and it was only the holiday pay that hadn't been resolved. So there was little dispute in terms of little disagreement, if you like, between them. Also, despite the use of, or the fairly early resolution by the respondent to use settlement agreements, that didn't necessarily indicate a dispute. It was simply good order and commercial prudence. It wasn't an indication that litigation was contemplated. Furthermore, the respondent didn't think it necessary to get legal advice. Also, neither party referenced their discussions on the 12th of October as being covered by without prejudice privilege. They didn't use the term at all. And so the tribunal said, well, there's really only a hardening of attitudes when you reach the December meetings and where the respondent produces its draft settlement agreement and the claimant provides his counter settlement agreement. This was appealed by the respondent. And there were 5 grounds. I just want to touch very lightly on them. Most extensively, the EAT deals with this question that the appeal that the tribunal had focused too much on what the respondent thought about it and whether the respondent contemplated litigation or not. But EAT didn't agree with that. It regarded the Framlington test as correctly applied and that the judge had considered both parties. And it recalled that there's no need to make an express finding about the respondent manager's state of mind. It's an objective test. And again, yes, the settlement agreement can be regarded as a sensible commercial tool, not an indicator of the contemplation of litigation. And it referred to this quite important and I think quite useful distinction to bear in mind. The awareness of litigation from an experienced manager is a theoretical possibility as against the actual contemplation of it. And that's something that I think can be overlooked when one thinks that any thought of litigation must immediately invoke the Framlington test. It doesn't necessarily have to. If it's simply something that a manager is conceptually aware of as something that happens. The second ground related to the tribunal's lack of regard, so the claimant thought, in the fact the claimant did use the term without prejudice privilege when he offered his counter settlement agreement in December. And the EAT said, well, no, actually, it's more relevant that neither party had used it during the October exchanges. And while it's not determinative, one shouldn't overlook the fact that the use or non-use of it is relevant. It is a factor that a tribunal can bear in mind when it's conducting the exercise of trying to determine whether there was a contemplation of possible litigation. Thirdly, there was a challenge that there'd been erring in the application of the open shop principle. The EAT rejected that, thought it was limited relevance. Fourthly, the ground of appeal that it was wrong to conclude simply because there was no dispute as to the reason of the termination, that meant that there was no dispute actually at the time of the discussions for the purposes of the rule, and that in fact the tribunal had erred in putting those two together, and the tribunal, the EAT said, was entitled to place weight on the fact that this was a no-fault dismissal, that there is a class of senior employee who are quite routinely have their jobs terminated because of the nature of the work they do. They're no longer required in the business, has nothing to do with their abilities, their experience, their conduct. It's not hostile, it's just the way the business works, and there's no ill feeling. And there are many, many such cases where no litigation ensues from that and no one thinks or expects it will. And that those sorts of class cases, it can be quite wrong to assume that that is a dispute for the purposes of establishing without prejudice privilege. I'm going to now pass on back to Louise, who's going to look at Garad and unambiguous impropriety.
Yes, thank you all. Hopefully you can bear with us as we jump back and forth a little bit. In the case, I've realised this possibly should have come after the discussion of Garad. Hopefully you can recall Amy's very helpful outline of the facts of Garad, which are quite helpful when considering the third round of appeal that was raised by Mrs. Garad, and that the discussions at the meeting within the golf club amounted to an ambiguous impropriety because of the way that they'd been conducted, the content and the pressure that was placed on her to accept a termination agreement. And the judge at first instance did make findings, and somewhat in contrast to a later case I'll talk about in the case of Summer, the tribunal did hear quite extensive, I think it was 3 days of evidence in Garad on the conduct in the meeting and what was said and how it had been said. And the finding that had been made was that the way that the meeting was conducted was amicable and professional. And so what was argued, and this round, or at the first instance, it was said that no, the meeting did not amount to an ambiguous impropriety and there's no reason to have an exception to the privilege rule. What was argued in the EAT by Mrs. Garad was that the threshold was too high, that this exceptional rule was much too high for people to meet. And actually, the relevance of what was said during the settlement discussions was relevant to her case generally, and it may amount to victimisation, the contents of the meeting. Interestingly, or slightly unsurprisingly, because of the exceptional nature of the unambiguous and proprietary rule, this round of appeal did not succeed in the EAT, Again, something that Amy touched upon in her discussions of Mesiato was that this case had not been pursued on the basis that the termination itself amounted to an unlawful act. So the claimant, or Mrs. Garad, was not relying on the meeting as being evidence as part of her claim that she'd been harassed or victimised. That was not one of the pleaded grounds of the claim. It went more to the context of the discussions and how she'd considered she'd been treated, and the fact that her grievance hadn't been fully considered by the employer. And the EOT considered the case of Unilever and Procter & Gamble from 1999, quite a famous quote that you'll probably all be familiar with if you've researched this without prejudice and unambiguous impropriety, that the privilege cannot act as a cloak for perjury, blackmail, or other unambiguous impropriety, which is where this exception comes from. What was interesting is that it was queried by Mr. Jesserbourne, who decided this case in the EAT, was really what the relevance of disclosing the meeting or the contents of the meetings would have on the claim. Mrs. Garad could refer to the fact that there had been some discussions on a particular date, and she was unhappy with the way her grievance had been handled. It didn't directly go to the issues in her claim. The second point is, again, paragraph 65, this balancing exercise and the policy considerations which the EAT were considering, and the fact that the exception or the protection would only be displaced with very clear and very serious wrongdoing. And so the findings made at the first instance about the way that the meeting was conducted, about the contents of the meeting, was relevant. And simply making a settlement offer, even if it was relevant to any discriminatory attitudes, was unlikely to meet the high threshold that was required to fall into this exception. This leads us on to the second recent decision on unambiguous impropriety, also decided by Mr. Jesserbourne in the EAT, actually before Garad, in the case of Swiss and Re Corporate Solutions Limited in summer in 2022. The EAT was considering an appeal on the admissibility of a letter that had been labelled without prejudice from January 2021. And the employer had made an offer to terminate the claimant's employment, but with a number of allegations about her misconduct or alleged misconduct, very strongly worded, amounting to potential breaches of data protection rules, financial regulation rules, and criminal conduct. The essence of the allegations, it related to the claimant's conduct in forwarding emails and blind copying in her husband when sending copies of her grievance, so that she had these documents to look at a later time. Well, that was the reasoning that she gave. It was said that she'd lied to her employer because she'd not informed them that she'd blind copied in her husband. And these allegations were set out in quite a detailed letter from the employer's representatives that had been prepared by them. Before that, and just looking briefly at the chronology, these issues or the concerns about data protection had been raised with the claimant, but notably a HR partner had said or had referred to the allegations as a low-level data breach. So it clearly, in correspondence, considered that they'd not been so serious to refer to them as a low-level data breach. The judge at first instance, Employment Judge Gruel, did consider that the letter was admissible, and it fell within this exceptional or narrow exception for unambiguous impropriety, because it amounted to improper threats and pressure to persuade the claimant to accept the offer. And so, taking a step back, it was the employment judge reasoning was very serious threats have been made, trying to force or put improper pressure on a claimant to accept the termination offer that had been made. The case was, there was an appeal in the EAT, and in essence on two grounds, but were broken down in the judgment into a ground 1A and ground 2. The first being that the employment judge had misdirected herself on the law, and there was consideration of the authorities, such as the Unilever case, and the communications court case, and the fact that it had to be a truly exceptional set of circumstances to prevent, or for the policy reasons and preventing erosion of the without prejudice rule, which Amy's touched upon in terms of allowing parties to enter into constructive negotiations, including to terminate employment. And actually what was found was that there had been no misdirection in the law by the employment judge. And I think paragraph 35 is particularly interesting because one of the arguments that was raised by the appellant employer within the EAT was the fact that it's fairly standard or commonplace for employers to refer to potential disciplinary proceedings or misconduct as part of settlement or negotiations as a bit of a stick to encourage people to leave. But what was said, I think it's a helpful point at paragraph 35, is that you can refer to potential disciplinary proceedings, but you're not free to raise such matters dishonestly or use them in an attempt to blackmail an employee or a claimant. The second two grounds of appeal, in essence, did succeed in the EAT. And that was because employment judge rule found that there was either no basis at all for the allegations that had been set out in the termination letter, or that they've been grossly exaggerated. And I think it's important to consider the context in the way that this hearing was dealt with, in contrast to Garad. Garad was, I understand that from my recollection, was a 3-day oral hearing where evidence was heard from both parties. The distinction in the summer was the fact that there hadn't been any oral evidence from either party on the letter, and yet the judge had concluded that there was no basis at all for the allegations. And what was argued successfully was that in essence, the finding shouldn't have been made on the evidence, that the judge hadn't conducted such a thorough review of the allegations and whether there was any basis to them at all. And it was conceded or was considered by the AT that there was potentially some basis in the allegations of data protection because of the claimant's conduct. And there was consideration of Firster and Firster from 2016. Particularly, in Firster, it was the threat of a quasi-criminal proceeding, so it was committal proceedings that were threatened to try and induce somebody to accept a civil settlement and a higher sum. And it was the relationship between the threats that have been made and the context. So in Firster, there was less connection, or considered to be a lot less connection, between the threat of committal proceedings and what was being asked to be accepted. Whereas in this context, and in context of employment proceedings, the disciplinary matters that were raised as part of the letter and the allegations, they were much more relevant and closer in connection with the settlement agreement. What was also stated at paragraph 54 was that there wouldn't be cases where no such category, apologies, I'll let you read the paragraph as it's set out on the screen rather than me mumbling through it. But in essence, that there would be context that even at a preliminary hearing, and you would be able to find that baseless or exaggerated allegations could lift or could amount to unambiguous impropriety. But it was the context that was very important, that you'd have to look at what the allegations were and whether there was any foundation within the allegations to justify making that finding. And on the facts, the judge had not sufficiently engaged with the merits in the letter and whether it could amount, whether there was any basis at all in fact. Again, it's helpful to note that this was quite a finely balanced case. And at paragraph 60, it was noted that the respondents' representatives had sailed close to the wind in making such strongly worded allegations and threats of criminal proceedings in this type of settlement negotiation. But again, this public policy balancing exercise was considered as part of the judgment, and that even the exaggeration would not be sufficient to amount to exception, whereas if it had been a threat or there'd been no foundation at all in the allegations, that might have amounted to unambiguous and impropriety and led to the document being admissible. I will hand you back over to Amy for the last.
Thank you, Louise, and talk about the last case, the icing on the cake, the case of Mika, which concerns an employee who suffered a back injury. He had a manual role which required heavy lifting, and he was told in January 2020 of the possibility that his employment would be terminated. His employer prepared a letter of termination on the 5th of February, and it was headed "without prejudice," and informed him that his employment would terminate by mutual agreement by reason of capability, and it named a last day of employment. It also contained a settlement offer. And the dispute actually that involved the tribunal and EAT arose around the effective date of termination and whether the claimant's claim was brought in time. That was his main reason for appealing. The tribunal had held that it was out of time. But in appealing, the claimant alleged that the tribunal had erred in treating the 5th of February letter as a letter of dismissal because it was covered by without prejudice privilege. And the EAT did not accept that. It placed weight on the pre-existing understanding of the parties that the claimant couldn't perform his role, and the claimant was aware of where the respondent was on that. But secondly, it said, yes, it might have been better to prepare two letters, one which was an open dismissal letter and one which was a without prejudice one, but it was perfectly feasible to have both open sections and discrete privilege sections within the one document. It could be done. What you needed to do was to consider the document as a whole to determine whether in fact this was the case or not. So that's a very brief look at Mika. And I think what we wanted to do was look at some of the practical considerations that arise from these cases, because of course privilege is constantly with us in litigation, and we're frequently having to consider often quite finely balanced questions on it. And we've set out some of these in the slide. The fact that although we say without prejudice privilege isn't, using that term isn't determinative, but in fact that doesn't mean that you can forget about it. It is going to be a relevant factor. It was in Evanson, and it is something that can sway a tribunal along with other aspects.
Certainly, and it's important when you're working with litigants in person that they might not necessarily understand, although that wasn't found in Garad, possibly in the context of individuals who had law degrees, that's a matter of fact. But the fact that simply labelling it without prejudice, if somebody does not understand and does not consider themselves to be in a dispute, may mean that it's not subject to the protection that privilege would give you. And so I think that's a very important factor for everybody to understand, because actually you will want to prevent the need to have a preliminary hearing on these issues. The cases that we've been considering, they're dealing with a preliminary issue prior to the determination of the merits about whether something could be included within either the claim form or in subsequent documentation. And obviously you would all want to avoid the need to have a separate hearing on these issues if you can, which is why it's an important point to consider quite early on in the context of sending correspondence and entering into negotiations, that everybody's very clear on the purpose and actually what is hoped to be achieved by the meeting.
Yeah, exactly. And I think it sounds trite, but it nevertheless continues to be true. Context is everything. In both the Garad and Evanson cases, you had reliance on broad brush legal assertions from BNP Paribas and Nomura that because there was a grievance, that meant that there had to be a dispute, or there didn't have to be a dispute. And context is everything. You need to look at the relevance of the reason for the dismissal, the tone of the negotiations, the expectations which the parties had, and also when you're, as the Garad case shows, when you're looking at the original grievance, how closely does that correspond to the matters in the ultimate dispute? That can assist you with determining possibly whether the grievance or the grievance meeting, or the exchanges connecting to the grievance are covered by privilege or not.
Exactly, and I think the Dundee case is quite a stark reminder about original reports and amending documents, even with the benefit of advice, that actually when versions are altered or they ping back and forth, in the context of an internal organisation, it wouldn't attract privilege at all. If it goes to your representatives and there are amendments made, it does not necessarily mean that the original copy of the report would attract privilege. And that's something to bear in mind when, if you're conducting an investigation or a grievance report, even after proceedings have started in the tribunal, that actually the original report may be disclosed and it may be relied on to show that any subsequent report is not fair or has been improperly influenced by lawyers or by people advising the person who's meant to be an impartial decision maker. And again, that goes to generally editing documents. It's just something to bear in mind when giving advice, particularly at a sensitive stage in proceedings where litigation might be contemplated. The last point, which we've just flagged, just links back to the case of Summer and the fact that in the EAT's mind, it did serve quite close to the wind. And thinking about, if you're setting out allegations in a termination letter, what is the foundation for those allegations? Is there the weight being placed on them trying to induce a claimant to accept a settlement? And that actually the disparity between the parties and their respective positions might tip something or tip into the balance of unambiguous impropriety. It is an exceptional exception to the rule of without prejudice correspondence, and it's not certainly going to be quite an unusual thing for the tribunal to find, but as Summer shows, it could happen, particularly where if there'd been further consideration in the first instance of the specific allegations by the judge, looking at whether there was any basis for them at all, and that had been considered more thoroughly. But I think all of those points are things to think about in the course of litigation and preparing settlement agreements and those negotiations.
I think what's interesting about the Summer case, what you're saying is that we're constantly told, and always have been told, about the exceptionalism of unambiguous impropriety, but just simply using in its judgment sailing close to the wind, for some might almost open the door slightly. Yeah. You can see the prospect of how it might actually operate and how it might be applicable, which is, I think, some might say, quite exciting.
Definitely, and I think in respect of the Garad and Evanson exceptions, one of the interesting points is if Mrs. Garad had relied on specifically what was said during the meeting, saying, well, this amounted to discrimination or this was harassment, then perhaps the case would have been determined differently on the unambiguous impropriety. And again, that it might have been a much broader or an expansion of the rule, rather than certainly turned on the fact that we made at the first instance and actually the way that the meeting had been conducted.
Before we take questions, we want to plug the annual employment lecture, which is being held on the 8th of November, Wednesday. Hey ChatGPT is AA after our jobs. We have a splendid lineup of speakers. We're very excited about it, and you can see the link there. So please do have a look, and we very much hope to see you there.
You can sign up and attend. So please do register interest. We hope to see lots of you there. The last section was if anybody had any specific questions on the cases which we've considered this afternoon, or any other questions about privilege or the topics we've discussed.
Okay. I don't appear to be any questions, but obviously we'd be delighted to look forward to seeing you at the annual employment lecture, and we can continue the discussion there. Thank you so much for attending. Apologies again for some of the technical problems. Clearly, new premises means getting to grips with a slightly different setup. And thank you again. And yeah,
good afternoon.
Bye.
Thank you.